I thought I'd make an audio recording for this one, but I'm not putting it on Facebook page. I'll go on YouTube. So this Elizabeth Countess of Powys, it doesn't say what the accusation is or the charge, but she basically had some men coming around to her house, demanding that they were going to search it and question her servants, right? Now, this woman is, like, obviously she's a countess, so she's a peer, right? But they come in at night time, right? At 12 o'clock. Don't know if they were trying to arrest her or not. They didn't have any warrant or order or anything, right? So she's claiming, privileges, right? But privileges because it's sessions of Parliament. And she's writing basically to the House of Lords, right? I think she was at Lincoln. Are these like kind of like joke ones or what? I think she's saying it Lincoln's Inn or Lincoln's Inn Fields. Isn't Lincoln's Inn Fields the actual place where the lawyers study? Like, isn't that where, like, Tony Blair went, Lincoln's Inn? Isn't Lincoln Inn Fields, like, next to where all the lawyers learn to study? So, again, we've got a white... She won't be a member of Parliament because they didn't have women in Parliament, did they, right? And this is, like, 1679, so this is before the Bill of Rights, but... Now what we've established, there are already some acts in law for privileges, right? Under James I. And others legislating about privilege. But those acts, I've just actually found them. And they're basically, going about, not being... imprisoned and to be able to go about your business if you've got a case or cause to be able to go about your business. And there was also another later act, but that's 1700s about because they used to lock people up if they owed, like in civil suits or this whole bail being put out on bail, right? The word bail and bailiffs. Now we use the word bailiffs to come and take your things, but they used to come for you, right? But now you don't get put in there. Like when the police put you in prison, they say, we're going to let you out on bail. And, usually if it's a serious case, you have to pay to get out. But they used to do that for civil as well, right? But now it's illegal to do it. They come and take your things also if you don't pay your fines. But they used to come and lock you up if you didn't pay your fines until you paid them and stuff like that. So it's all kind of changed. In a way, it is a privilege. In a way, we've kind of got a privilege that if you don't pay fines, you don't get locked up. They just come take your things instead. That is a privilege compared to what it used to be, right? I don't think some people appreciate that now. Now, the thing is, right, that what I'm scratching my head with is this, that there's a Magna Carta, the Magna Carta clock. In the Charter of Liberties, it said that barons and lords and barons, etc., have to stand for their crimes, right? They have to stand for their crimes like anyone else, right? Okay, so they're not immune. Now, this is when Magna Carta, they argued that, that they wouldn't be tried by, peasants because maybe they wouldn't treat them fairly or whatever. This is the whole thing to do with Magna Carta. See, Magna Carta really was a big protection for these peers. But the thing is, that means that the peers will be getting tried at these 100 courts unless it was serious, one thing we're not hearing mention of at all in any of these petitions, which I've picked out, these like 100 or so sample ones with privilege, nothing is in whatsoever is in the divisional hundreds court, which exists. The divisional court, the hundreds, right? That's a court, okay? So it's like the courts that common people have. None of them are in those courts. It's usually chancery, quarter sessions, or assizes or so. Now, the thing is, with those courts, which are like quarter sessions of 4 times a year, and assizes were twice a year, and then later times 4 times a year, they're usually sat by the judges who come from London, right, on the circuits, and they're usually either knights, with titles, or they might be earls or barons or lords themselves, right? Could be earls, barons, lords, right? So that's the thing is, if they are sitting those assizes, then they I don't know about whether, because they don't have to. Remember, you didn't have to have a jury, but I don't know if the jury. The question that I'm asking now myself, scratching my head, is what I don't know the answer to. Does Magna Carta mean that the judge has to be, equal to these peers who are being tried, but they can have a jury there who decide the verdict, but the judge makes the order, right? Or are they not allowed to have a jury of common people at all whatsoever? But they used to have juries in Westminster, right? But there wasn't just barons and lords going to Westminster. There was all kinds of different people appealing to Westminster as well, right? That is the thing that I need to know the answer to. Does it mean that the judge sitting the trial has to be equal to them because he makes the order, right, and finalises it, right? He's the one who finds them at the end with the sentence. The jury just gives a verdict, right? Or was it like they can't have a jury? Because the thing with the thing with the Hanningfield case is that it was only Alistair McReef. Now, Alistair McReef, okay, he's only a judge, right? Alistair McReef, okay, a justice, just because someone's a justice is they're not a peer. They're a judge, not a peer, right? It's magistrates are judges, but they're not peers, right? There was a jury there, but Alistair McReef, I don't think Judge Alistair McReef is equal to the Lord Hanningfield, is he, right? But if it had been, or whatever, but I thought there was a special process where they could only be, tried in Parliament, actually in the Parliament with the other barons, like they had to kind of like, it actually was a trial, with the barons voting on, a little bit like in Congress, when they can impeach someone type of thing. But that doesn't seem to be the case, because if it's into the time of Parliament for that, then you would want it in the time of Parliament. If Parliament was in session, right, then that's what you want, because if it's in session, then the peers are assembled and they can judge them. If Parliament's not in session, then you can't be judged by your peers because they're not assembled, right? So it would be counterintuitive. Instead, this woman in this case here, she's going on about, they all keep going on about it being during sessions of Parliament, but that is for MPs. Now, if they've got a husband who is a member of Parliament and he's serving, then he can't be arrested or charged during sessions of Parliament because he's got to go in there. But his wife doesn't. His wife doesn't have to go in there because she's not a member of Parliament, right? Now, anyone who's arresting someone for a crime or offence can pursue them and go after them, obviously, like the police do now, but we had, people were doing that. People were arresting people because they were bringing civil cases against them and so forth. That's Lex Talionis, a right to pursue your cause and be protected, right? Which is kind of similar to what's happening with Parliament. But the thing is, all these women, they're claiming this House of Parliament to do with the sessions or not. But if they're not a member of Parliament, why would they have parliamentary privilege? Unless they're claiming that their husbands have got it. But and this is the thing, right? In the 1688 confirmation, which clearly is now just a clarification and confirmation, it's not like creating some amazing new right at all whatsoever. It's just like a reaffirmation and clarification of these previous of Magna Carta, and they've actually got some privileges. If they're real, we don't even know whether these other things have been planted now or not. Who knows for sure? But anyway, we'll go going along with them, right? So look at the 1688 Bill of Rights as an example. It says illegal prosecutions by the King's Bench for matters cognisable, decidable, debatable only in Parliament, right? Now, if you are the widow or even the wife of a baron or lord, right, then illegal prosecutions by the King's Bench, like that clause is nothing to do with you. Because the thing is, right, if you were prosecuted at the King's Bench, you can be prosecuted at the King's Bench because the King is equal to you, right? If it's the King's Bench, then you can be prosecuted. If you're the wife of a peer, or even the widow of a peer, you are a peer, right? Why is it legal prosecutions at the King's Bench? Because the King's equal to you, right? So what the fuck has that got to do with, you don't need to be a member of Parliament because you can be prosecuted at the King's Bench. Because it's the King's Bench, so you can be prosecuted there, right? Or whatever, whether it's, come on please or whatever, Westminster Hall, right? Okay? So, you're at the level where you can be prosecuted, right? Now, whether your husband's a member of Parliament or not, what's that got to do with anything, Now, if your servants have got privilege, then the servants can be prosecuted at the King's Bench as well, right? But probably not the Hundreds Court for sure, or whatever, right? They've only got the privilege of being prosecuted at the King's Bench. The privilege of Parliament is meant to be for MPs, so they can come and go and do the work, right? And maybe their servants as well who need to do it for Parliament, right? And as for the King's hat maker, that guy had to have permission to bring suit, but I don't understand it because, at what level of court? You don't need permission to bring suit if he's doing it if he was doing it at the King's Bench. Some of it doesn't really add up. And then there's these other acts that come into it as well. Because really that illegal prosecution by the King's Bench, that does apply to us if we're bringing a petition. Because it matters, if you're bringing a case to Parliament, it is a thing that Parliament is going to be looking at or deciding on, right? That's the thing. Just like if you go to a Crown Court or a County Court or Magistrates Court or whatever court, or High Court or whatever court, but it's a court of Parliament. So that legal prosecution, now, this is the thing with Jeremy Johnson KC, right? Lord Hindfield could have been prosecuted at the King's Bench, but that wouldn't matter whether he was doing work for Parliament or not. So the illegal prosecutions by the King's Bench for matters decidable, debatable only in the Parliament, that is more relevant to the peers as well. Because, as with Hanningfield, right, I don't think, you see, Hanningfield, therefore, if he was doing matters of Parliament, it would be reserved for Parliament, right? But Hanningfield, because he's a Lord Hanningfield, he wouldn't be able to be prosecuted in a Crown Court anyway, I don't think. Because it's only Alistair McReef there. It's not the Supreme Court, surely. It's definitely not the King's Bench. Unless they're saying that, all of the circuit judges are equals to the Lords and Barons. But I don't think they all are, though. Are all justices equal to Lords and Barons? I don't. They can't be because they're just a justice, aren't they? They're not like, it's not like Lord Chief Justice or whatever. That's why I mean that's the whole point of Parliament. That's the whole point. Some judges are members of Parliament. Some judges are members of Parliament. And they're like members of the House of Lords. Because that's the whole part of the Commons and the Lords, isn't it? You got two houses. Commons for Common and House of Lords for Lords. That's the whole point. So the whole Lord Hangfield case was rather ridiculous, really. So now, I mean, there's a few more books I've found that exist, and also some acts of law which I hadn't found before, and one of them is on the legislation website, and it's not published in full, and they haven't got the old version of it that has been. The first three clauses aren't there, only the fourth clause, which is actually affects us a lot to do with if you owe money to the government, like fines, which is kind of like permanent bail. It's a privilege to not have to be bailed out of prison if you owe the government money. Which that is a really a privilege now that we've all got and been given in law, which is quite it's funny that they call them bailiffs when they come round to take your things, because they're not coming around for you, to put you in prison until you pay a fine. Maybe some of the ULEZ people rather be locked up in prison, like Roger Hallam. Roger Hallam is in prison when he shouldn't be. No one's saying, "Oh, we'll bail him to get him out. We'll give him some money, to get him out." Some of these ULEZ people, maybe they'd rather sit in prison and not have their car taken away. But in Magna Carta, apparently, you can't take people's cars away. So, all this coming and taking people's cars away that's been happening is really, really quite vindictive from the government, because they know that they're not supposed to take people's cars away. Anything in history that they're not really supposed to do or not meant to do, they've gone and done it. And I think they like to make an art out of it, like it's the muses, it's amusement, all these things that they're not allowed to do, but they're doing. It's an actual miracle. It's a miracle that they don't come and arrest us and lock us up until you pay a fine, if you owe money. So it's amazing that they don't come and lock you up, only because they actually want the money, don't they? It's all about the money. They want to get the money off you. And that's the thing with magistrates' courts. If they had a jury there, people would have been acquitted a lot more. But I really think they went and did, when they went and did one with those Magna Carta appeals, when apparently it cannot be changed because of the confirmation of the charters. Surely. But there's the principle of it, because how do you even pay fines if you can't work? That's the thing. But anyway, there's some. We need to find out what qualifies as peerage. Because when it extended to the servants as well, that's ridiculous. I mean, because servants aren't peers, so, but the peers aren't. The barons and lords are only protected so they can be judged, but only by their equals. So surely the servants can be judged by their equals as well. It's only protecting them from the common courts. This whole Parliament session thing is for members of Parliament. Not all of the peerage were members of Parliament, but they're claiming it for this session period. But not all of them are actually doing work for it. So I don't know where they got that from, but she was wanting to read those acts a bit more, but I found them now, so it won't take us long to figure it out.